So we are here in the matter of Medina versus Doc, case number 18-08623DS. I guess, is Child Protective Services still involved?
Yes.
No, sir. They got closed yesterday.
Okay. Did they close it to your knowledge? They don't close it to
Yes.
your knowledge, Miss Medina. You don't have knowledge that they closed it?
Nope. No.
All right.
They told her.
Well, I won't ask if the sky's blue because I'll get a different answer from each of you. All righty. What was the underlying issue of the CPS case, Miss Medina? This is your motion, so I'll ask you that question.
Okay. So CPS was contacted due to Daniel abusing Brenda in front of the children.
So
So
it was a fight between his current significant other and him.
yes, Miliana described that Daniel dragged Brenda from the room to outside.
And therefore the children were present for the alleged event.
Yes, they were. And they said it happened multiple times.
Okay, Mr. Doc, are there any police charges or?
No, sir, that's a lie. And she talked to CPS herself. So this is all lies. Made up allegations on her end because she's mad because she wants to take my kids because she gave me half custody because I earned it. I deserve full custody, honestly, because my kids have been neglected to learn. They're getting held back because of her don't want to be in the state on time.
You know, I've got allegations enough in the pleadings to send this to the front of the court.
We'll do what we got to do, sir.
For custody, parenting time, and child support issues.
Yes, I also.
All of them are up for. At this point in time, I will tell you, Mr. Doc, that according to the previous court order, she has sole legal and sole physical custody now. Parenting time is a separate issue. But it's my understanding you guys came to some agreements, but there are no agreements any longer. And I don't have a court order really listing what those agreements are. So I will send it to the front of the court to get a proposed court order to solidify what the arrangement should be.
Okay. I have a question. Were you able to get my video as well?
Yeah, I was trying to figure out what the heck that was. I was able to play it, but it didn't seem to make any sense.
Well, that's another thing too. So my children have been witnessing Daniel selling drugs as well.
Okay,
so
yeah, but
that's
all it was
thing.
somebody sitting in a car giving me a diatribe, and I'm not sure that
Yeah, so it was
that's not really evidence of anything. I mean, it was, I'm kind of like, okay, but not helpful.
Okay.
So, all right, but I will send it to the front of the court for custody, parenting time, and child support. Okay.
Okay, thank you. So when do you think we'll be getting a court date for that? So I can also
they should be
send in the other
contacting,
video.
they should be contacting you in the next couple of weeks to set up an appointment to meet with both of you. And yeah, they can look at a lot of that stuff. So the court doesn't necessarily get to look at that stuff. It's got to be entered appropriately, which is why the only reason that I even attempted to watch what you did was because I wanted to see what the heck it was. But it's nothing to the court at this point. It's not evidence. It's not anything. It's nothing. Evidence comes to the court through a witness in the witness stand.
Okay.
So you don't just, what you just handed the court is an offer of evidence, basically. This is what I think I have as backup. Now, the front of the court can look at that stuff and make determinations based on it. Sir, you'll be able to do the same things.
Okay.
You'll be able to show, and, maybe they want to talk to each of your significant others.
Oh, that's perfect.
But you can ask them to. So, and they have the right to contact CPS as well. CPS is supposed to cooperate with the front of the court to ensure that orders are issued properly for the protection of the children, if necessary. And if it's closed, it's closed. But that's still pertinent information, Mr. Doc. And the pertinent information may be that they don't find anything wrong.
They're not going to find anything wrong.
Well, and that's what I mean. I mean, it can help you or hurt you. I don't know what the facts are.
It's gonna help me, sir. And at the same time, we haven't been together, and she's been falsifying.
This case is 7 years old. So yeah, you haven't been together for a while. So
no, hold on. We haven't been together since July. Let's put that on wax right now. Since July.
You guys got back together after the case started?
Since July, we have not been together of 2024.
He took me to court for the kids in
February. All right, guys.
All right. Since my kids were younger. We've been together since birth.
All right,
And
because
just until July, we haven't been together. So
okay,
whatever she
yeah,
put
I'm
down on
sorry.
paper
The case.
lies.
Well, the case is a 2018 case.
Okay.
I didn't know you guys got back together. That's not in the
Yeah,
case.
we've been together the whole
Okay.
time, sir.
All right.
He's
Well,
been
that's
lying on
why
paper.
that's why it's again there's nothing on
Right.
paper. The only paper is the fact that they entered a child support order. You guys didn't bring this case. The prosecutor did because of state aid being involved.
Okay, what she put in writing, if you look at it, it doesn't
I
make
looked
sense.
at it. That's why I said, and I'm trying to get both of you through this because you don't have any orders in the court file to say who has what. So
Okay,
parenting time is necessary, and so
exactly.
yeah. All right. So let's get you through this. I can't again undo what you guys have been doing for years.
So just to clarify, I have sole custody, right, of the children?
On paper, yes. But if
On
you guys have been
papers?
living, but if you guys have been living together, the custodial environment is who the
No,
children
we
look to.
haven't. Oh,
We
so they
have
go with me.
we have been living
Uh,
together, sir.
They've been with
He's
Guys,
me.
lying.
Well,
the
I'm
cust
trying to talk, but he doesn't let me.
I
That's what I'm.
was too, but you won't let me either. So I'll send it to the front of the court. Have a good morning.
Thank
Thank
you.
you.
Good.
You're here in the matter of Katzman versus Studebaker, case number 20-03197DM. Sir, this is your motion. What do you have to add to it?
Yes, I'd like to start with, can we start with the tuition motion?
Okay. What
There's
about the
two.
tuition?
Well, I'm just gonna read what I wrote. Your Honor, paragraph 5 of the divorce judgment requires the plaintiff and myself to equally share the tuition costs
Right.
for our sons at Triunity, 50-50.
Right.
To date, there has not been transparency regarding these payments aside from the letter the plaintiff submitted.
How is there the transparencies from the school? Is the school not communicating with you what the bills are?
I'll answer that question right here. So on October 3rd last year, I requested billing transparency from the plaintiff. She responded that she does not handle billing and directed me to contact the school. See exhibit A. When I contacted the school, they informed me the plaintiff had instructed them not to release any tuition payment records to me. See exhibit F.
If you're paying it, you get it. You get copies of the bills. That's all there is to it.
Okay, well, so my request, then I'll just skip to my request, is that to ensure transparency, avoid future disputes, and reduce the need for further court involvement, I respectfully request the court to issue an order stating Trinity Christian School may release full tuition billing and payment records to both parents of Emerson and Everett Studebaker on an annual basis with any financial aid information for either party being redacted. I'm not getting financial aid. The plaintiff has expressed that as a confidentiality issue. I stated in writing to her and the school, they can redact all that if they want.
Well, bottom line, I think your court order says that you guys will pay 50-50, correct?
Correct.
50-50 means 50% of what is actually paid.
I do agree. I was trying to be gracious, but it's been a battle for 6 months.
Ma'am, what's going on?
Yeah, so the school's policy is to split the total tuition, which
Okay.
is like $7,420.
Okay. So
And
you're talking
then
about
they have
$3,700 each, correct?
Correct.
So
yeah.
you actually
And
pay
then-
3,700 and he pays 3,700.
No.
I'm
Correct.
asking the question on
And
purpose.
then
Okay. So you actually pay 3,700 or is your bill reduced?
so both of our bills are reduced because my mom works there and we get a
Okay,
50%
so both of your bills
discount.
are okay. Both of your bills are reduced.
Yes.
All right. That's what I was trying to get to. Okay. Because if that's the case, I am going to issue an order saying that Tri-Unity Christian is to give him copies of the bills. He's allowed, if he's paying a bill, he gets to have a copy of it.
He does. So our billing is like split there. They basically take both of the boys' tuition. Because we're divorced, they can pay our bills like separately, essentially. We both have like an account through their system that
Right.
deducts that amount from our accounts every
And sir,
month or whatever.
you're concerned because you don't believe you're paying 50%. You believe you're paying more than 50% because she's paying less. And you just want confirmation of that, correct?
Correct. I think the school has worked it out now, but because this has been a battle for 6 months, I'd like confirmation now and going forward so we don't have to come back to court.
All right. So if I take both of your statements as it is, it sounds like there's a reduction here because one of the parents, one of the relatives of the child goes to the, works at the school, and that's great. And then both of you should receive proportionally that correct deduction. Again, 50% of what's actually owed is what should be paid. So yeah, they should be giving him copies of all the bills and what's owed on the children. Next.
Thank you. So we're done with that one then?
I guess I'm issuing
Okay.
the order. I'm going to issue an order that says that Tri-Christian is to openly give you copies of all bills.
Thank you. So the
So I
next
guess my
issue,
question with that,
Yeah.
so just to be clear, I don't know how that helps anything from what Andrew's stating. He's asking for my like
I'm asking him
payment
for any.
record.
Well, I think that's legitimately requested. You're telling me you pay 3,700. He'd just like to confirm it, that you each are paying the equivalent amounts. Because if you're not, he has a whole nother matter here.
Correct, and I understand that. I think for me, my concern comes down to the fact that the school has like put it in writing that that's the case. I have told him that's the case, and we're in court over that. Like it seems.
And the court is issuing an order saying you will divulge the underlying documents that show it.
Okay.
Again, I'm taking you at your word. For now. He has the right to review that and make sure that what you're saying and what they've said is the truth. When you start to
Sure.
hide stuff, that's when people start to question more. Just telling somebody something or sending them a statement going, we do it, is not enough. Background documents are also something that should have been stated. Okay. Like I said, if he's going to be ordered to pay a bill, he gets copies of what the bill is and the necessary documents to show that it's an appropriate amount. Because again, it should, hopefully from what you're saying, it should show that each of you are paying equally. If it does not, he has a whole nother matter here, and he has the right to make that
Correct.
request.
I understand.
Okay. You know, if he were an attorney, what he'd probably do is just issue a subpoena for all the records from the school, and the court would have signed that. All right, next issue. Next issue, sir.
Sorry, I was taking a note. This is regarding Our Family Wizard and communication, Your Honor.
Yeah.
I respectfully request an addendum to the December 2021 order regarding Our Family Wizard or a separate order as the court deems appropriate, as outlined in the motion. This request is intended to promote open communication.
Yeah, I can't do that. I can't order third parties to be involved in My Family Wizard. That's between the two of you. You're asking for the student, for the what, all professionals involved.
I'm asking for the opposite, Your Honor.
Okay.
The plaintiff is trying to force, has told the boys' counselor, the school, and doctors that they cannot communicate with us in any manner on the same platform. She's tried to force them to go to Our Family Wizard.
No, they cannot. No one can force them to go to Our Family Wizard. You have the right by law and by court order to talk with any professional involved with the children, any school personnel, any medical treatment, any dental treatment. Both parties have the right to contact those people and talk with them. No one has the right to stop that. You are both legal parents of this child or children, and therefore you both have the right to do that.
Your Honor, what the plaintiff has told them is, we'll take one example, the boys' counselor. She has told the counselor over and over and over that the counselor may not communicate with us jointly on an email.
That's not accurate.
That's what I was going to ask. The counselor has the right to choose who they email and how they email. So if the counselor wants to put both of you on an email, they can. If the counselor has an issue with one of you over another, they have the right to contact the other person. The counselor controls that. So, but it's not through My Family Wizard.
Your Honor, what I am asking for is an order or a letter that I can take to these professionals, because they've been told, like in my exhibits, I give, there's multiple letters in there from the counselor where she has requested even something as simple as